Bonjour, hello, my name is Matthew Fletcher, and I am a professor here at Michigan State University College of Law and director of the Indigenous Law and Policy Center, and I'll be giving this morning's talk. And I want to apologize again for not being able to make the convention this week. I have some administrative duties here at the law school that I can't get away from, but I really appreciate your flexibility and your patience with me, and I hope that this video presentation will suffice to start today's discussion. I'm going to be talking today about, and I think the title of my talk is Indian Courts and the Future Revisited. And this is a study funded by the federal government and performed by NYJA way back in the 1970s. It was ultimately published in 1978, and a report was published and written by David Getches, now the late David Getches, former dean of Colorado Law School. So I'm going to talk a little bit about that report, and then I'm going to move on to sort of the context of the report and the time that it came out. It's very interesting to read a report that doesn't take Oliphant into account, for example, and I'll get to that. And I'll look at some of the conclusions to that report, and then I'll compare some of those conclusions about the state of Indian courts in 1978 to the state of Indian courts right now. And since we don't have a similar study to the 1970s study, I'm going to sort of borrow a little bit and play with a little bit with something that Walter Ecclehawk did with his recent book, The 10 Worst Supreme Court Decisions of All Time. And I'm going to try to give you what I think are 10 of the very best, or at least most interesting, tribal court opinions of the last 10 years or so. And that will be sort of a jumping off point and a conclusory point to how we're going to talk about Indian Courts of the Future from 1978. So the report, Indian Courts in the Future, which is a book published by NYJA back in 1978 and written by David Getches, is an interesting snapshot in time. You would think that now that 30-some years had passed since that period of time, that there would be dramatic changes to tribal courts, and I think there absolutely have. The report was based on a survey sent out to 23 tribal courts, and an earlier report of NYJA had indicated there were something less than 100 fully functioning tribal courts in the United States in the mid-70s, and so the report here involved a study through a survey of 23 tribal courts, asking them a wide variety of questions, everything from how much funding do you get from the tribe as opposed to the BIA, what kind of training do your judges have, what kind of procedures do you have available, do you have judicial independence, what kind of codes are available for litigants and the judges to apply, what kind of support do the judges have. All of that is discussed in the survey and then later summarized in the report. In general, the report concluded that tribal courts had a long way to go and that funding amounts were very small. Mind you, this is the 1970s, long before significant amounts of gaming revenues, long before tribes had much going on in terms of self-determination. Self-determination contracts were brand new back in those days. Long before tribes really took control of their mineral estates, their natural resources. And so revenues for tribes were relatively low at the time. And so funding levels for tribes were very low. And consistent with what I guess you could say Congress found in the 1960s before Congress enacted the Indian Civil Rights Act, you see a lot of ongoing concerns with tribal courts. And for tribal judges specifically, probably the largest concern, other than resources and funding, was judicial independence. That said, tribal courts were engaging in a lot of creative and progressive initiatives that we've seen a lot of improvement in and a lot of development in the last few decades. The interesting thing about this report for me is that you read it and it says it's published in 1978 or 1979, but it's written and concluded at a period of time after the Supreme Court has granted cert in Oliphant versus Suquamish Indian tribe, but before it's issued the opinion in that case. And it's written as if it's likely the Supreme Court is to affirm that decision. And unfortunately, as we all know in this room, or you there, know that the Supreme Court in 1978 came down with a very devastating opinion saying under no circumstances can any Indian tribe in the United States, not just Suquamish, exercise criminal jurisdiction over non-Indians. And so much of the report is, at least assumes that the Supreme Court is probably going to affirm at least some aspect of tribal authority, or at least keep open the question. The Suquamish tribe at that time was a very small tribe, and just started a court. In fact, its tribal court at that time was known as the Suquamish Provisional Court. And so it was possible that the Supreme Court would say maybe Suquamish doesn't get to exercise criminal jurisdiction over non-Indians, but we'll leave open the question for reservations like Navajo, Tohono O'odham, Crow, where there are large landed reservations with a long, significant government presence, and not so much of a, not so much of concern for the Supreme Court. Unfortunately, the Supreme Court went in line with a right line rule and struck down all of tribal sovereignty in this context. The other context of the report I think is very interesting is that the American Bar Foundation sort of commissioned one of its regular researchers who'd done a lot of research in a lot of other areas like mental illness and courts and that sort of thing, juvenile justice, and asked him to do a study of tribal courts, almost at the same time, or at least contemporaneously to the Niger report and study. And I took a look at this. The study is by a guy named Samuel Brackle. Many of you may have heard of him or at least seen his report. The study is called, actually I forget what it's called. I should have the book in front of me. But it basically says it's not equal justice to go to tribal courts. And if you take a look at the methodology of the study, what Mr. Brackle did was he sort of dropped in on about 2 or 3 Indian reservations they'd heard of, literally just walked around and asked people about the tribal court. He did talk to some tribal judges here and there. He went to a couple of tribal court trainings that the BIA and other foundations were putting together, asked people some questions. In other words, I'm trying to give you the sense that this is about as non-scientific a study as you can imagine. Now, empirical research with legal researchers is a relatively new phenomenon. And I have to say, taking a look at Mr. Brackle's study, which in many ways takes many of the same conclusions factually that the Niger study takes and reverses the actual conclusions and says, well, yes, tribes don't have judicial independence so much, at least the tribal courts don't have judicial independence. Where Niger says we should strive to improve that situation, Mr. Brackle concludes we should just get rid of tribal courts and we should turn the tribes over to the feds and the states. And where the tribes don't have sufficient funding or resources to fund tribal courts and other government services that are related to tribal courts, such as jails and social services for Indian child welfare, NYCHA recommended increased funding, increased support and resources, and Mr. Brackle said we should get rid of tribal courts and turn the tribes over to the states and the federal government. It's not entirely clear. I'm giving you the sense that this is the context of Indian courts in the future. So in 1978, you get a sense of what the state of Indian courts were. It's very conceivable many of you in the audience were tribal judges or tribal court practitioners back in the 1970s, although there were far fewer courts. And I'm going to move now toward discussing sort of the modern era of tribal courts. 1978, we know that there were probably less than 100 tribal courts. It's gotten to the point now where we don't know exactly how many tribal courts there are, in part because there are so many. I always tell my students that the estimate, I would say, is closer to 300 or perhaps over 300 tribal courts. B.J. Jones' group over at the University of North Dakota did a study in the mid-2000s, the mid-aughties, I guess we would call them, suggesting that the BIA has, or finding that the BIA and tribal justice from the federal government have funded grants and research opportunities for 294 tribal courts. It's very likely that almost all of those tribal courts have at least begun the process of establishing themselves as a court, and there are probably others in addition to that. So I'm happy to go with 300, though again I think it's important to learn exactly how many tribal courts there are. So the state of tribal justice systems now, I'm going to do This is sort of pathetic, but I want to do a little pitch for my book, American Indian Tribal Law, which is the first case book for law students and law schools on tribal law, and gives you a sense, and I do it through a series of 14 chapters, mostly through cases and a little statutes and some law review readings about what tribal courts look like right now. Every conceivable kind of adjudication you could imagine has occurred in tribal courts. I found cases on incredibly difficult and complex business and commercial subject areas, as well as highly complicated and sophisticated property rights cases based entirely on unwritten tribal law. It's a very exciting time for tribal courts and for tribal justice systems, but many of the same concerns that the report from 1978 found remain extant. Tribal judicial independence has improved dramatically. Many of the tribes that in 1978 had a model IRA code, for example, a model IRA constitution, or a constitution at least established in the years following the Indian Reorganization Act, have amended their constitution to provide for at least some form of tribal judicial independence and separation of powers. And that's a huge step. And a lot of tribes have done that. In Michigan, it's only been since the 1980s, the early 1980s, that Indian tribes have amended their constitutions or changed their rules so that tribal courts will be judicially, or at least governmentally, independent from tribal councils. That doesn't end all disputes naturally, and we can talk a little bit about how that moves forward, but it does at least give you a sense that after the report in 1978, which I suspect was incredibly influential amongst tribal communities and tribal policymakers, tribal independence is a very serious policy choice that tribes have made. Tribal criminal justice has improved dramatically. Tribes starting in the 80s, as many of you well know, started things like peacemaker courts, modeled on the Navajo system, drug courts that have sprung up in part exactly along the same lines as many state courts in order to get juvenile offenders and first-time drug offenders, nonviolent criminals, out of the criminal justice system and divert them as much as possible. And I would also add that the cooperation between tribal courts and local courts is improving, and this is something that was barely even discussed in the 1978 report. It was virtually unheard of at that time. And I suspect many of you will argue, and rightfully so, that in your communities, state and tribal cooperation still remains virtually unheard of, or at least riddled with complexities and difficulties. I come from Michigan, and we're a little bit spoiled. Many of our tribal courts, if not most of them, have really excellent relations with local units of government, everything from probation officers to state courts and juvenile justice, as well as Indian child welfare programs and social services in the counties in which the tribes are located. We have a very good relationship with the state going all the way back to the 1990s and maybe possibly in the 1980s. Some tribes have had difficulties with law enforcement and public safety agreements, but most of the tribes have them. And all of this is probably based on a foundation that was established in the early 1990s, I think specifically in 1994, when the Michigan Supreme Court enacted Michigan Court Rule 2.615, in which is basically a reciprocal comity agreement. So long as a tribe adopts a similar court rule, Michigan state courts will recognize through the process of comity, not the funny comedy, the legal comedy, the judgments and orders and even records of tribal judges, tribal courts, and vice versa. That has laid the groundwork in Michigan for an enormous amount of activity, and there are omnibus Michigan tribal state tax agreements in which the state of Michigan has actually agreed to adjudicate many of the disputes that would arise under the tax agreements in tribal court because of